Hello and welcome to Making Law Simple. My name is David Helm, a licensed practicing attorney in the state of Michigan. And today we're going to be talking about opening statements. Welcome, everybody. I see Dolly Talk in the chat. I see Fox in the chat. Scott, what is this Dark Lotus? Is that Lefty? Dark Lotus? What is that now? Oh, that's worse than your last name. But I dislike the stream. Well, you know what? That's all right. You can dislike the stream. It all counts. It all counts. Let the trolls begin. Actually, because I haven't been streaming very much at all, if ever, I don't know how many people are going to actually get this notice. So we'll see how this goes. But I'm gonna. I want to educate you all today. I feel like my job is on YouTube anyways, is to educate, at least to some degree. And but today this is like very much an educational one. I actually have a PowerPoint for you all. Because I watched the last trial I streamed was the Christopher Schurr trial, and I streamed that with Nick. And the defense's opening statement was abhorrently bad. It was so bad. It was the worst kind of high school debate opening statement nonsense that I've ever seen. While at the same time, the Karen Reed trial was going on, and we had a very good statement, opening statement from the defense on that side. And I will say that both cases resulted in the same. So I'll put that out there. Well, sort of. The Christopher Schurr trial ended up in a mistrial, and the state decided not to prosecute. I think they had a weak case to begin with. And that mistrial and the defense victory was in spite of the defense, and particularly their opening statement. And I don't mean to pick on this one attorney. I don't know her. We did a little bit of background. She seems competent. She's practicing for like 5 years or so. Seems to have trial experience. She was one of three. There was 3 attorneys on the team, but this was just bad. And it got me thinking that I want to do a stream where I talk about what you should and shouldn't see in an opening statement. And so I put a PowerPoint together, and this PowerPoint is largely drawn from a textbook that I had in law school. It's called Trials and Practices, or Trial Practice, or something like this. It's from Thomson West, which is a known legal publisher. And I knew they had a section. They have a whole chapter dedicated to the opening statement because it's kind of important, right? And so I pulled some text from that. What I might do is actually put the entire chapter in my Discord after this for members that have access to the Discord. It's not my Discord, it's Jung's, but so you guys can read it if you want to. And then I thought we'd have some fun. I created a checklist. So we're gonna talk a little bit about the importance of an opening statement and what it means and what it should be. Then we have a checklist. Then we're gonna watch the 2 opening statements. We're gonna watch the Christopher Schurr one. I think we're gonna watch the bad one first. I don't know. I haven't made up my mind yet. And then we're going to watch Karen Reed. And we're going to like check off and be like, all right, this is, maybe we can see mathematically why one is so bad and the other one was so good. Dead channel, I thought. Oh, Dark Lotus. You're not Lefty, but welcome, sir. I thought you were Lefty for some reason. I apologize, sir. I apologize for besmirking and defaming you in such a way to confuse you with Lefty. And for that, I will forever be in your debt. PowerPoint, I'm out. It'll be fun. It'll be fun. All right, let's see here. So that's what we're going to do. The PowerPoint's not that long. And it's informative. And it's going to give you the tools so we can very viciously critique this first opening statement that we're going to watch from the Christopher Schurr trial. If you guys didn't follow it, it was a good trial, somewhat. I got very frustrated with the defense, but it was an interesting case. It was a Grand Rapids police officer who shot and killed a suspect during a traffic stop, and he was charged with murder, second-degree murder, and it's one of those cases where you see the videos from the news media and you're like, oh, he's kind of guilty. But then as the trial progressed, I thought, you know what? I don't think he is. And so I always pride myself on being he's absolutely innocent until proven guilty. But that video that was out there was so bad. I had to be like, yeah, like he's got to prove his innocence. And it went against like every logical lawyering part of me. But he did it in my mind. He did it. I don't think he was guilty. And ended up with a hung jury in a mistrial and the state not willing to re-prosecute. So I guess a successful outcome. What is wrong with our names? So I don't know, but apparently YouTube has removed like our handles and will only use the ones that we initially signed the account up with. So if you notice, my MLS in chat is not in brackets anymore. It's just, I think it's Making Law Simple. I don't know. Something happened. It was weird. But welcome. I'm happy to see at least 24 of you, 15 of you in YouTube, several of you on X, and whoever is watching over on Discord. Awesome. Not Discord. Twitch. Welcome. I fixed it. What'd you fix? All right. And if you guys hear some roosters in the background, I do have chickens. They are below me, or their house is below me, but they're wandering the yard. And unfortunately, I have 2 roosters right now, and they're kind of broken. We need to reset the clock on them. They go off all the time. Actually, it's 6 o'clock now, my time. And now they go off like every 6 hours. So they'll be going off throughout this. That guy is cool. Well, we'll see. Snibbles, welcome. Show the chickens. I don't have, they're not, I have the camera set up, but they're not in the coop or their hen house right now. They're actually roaming the yard, probably getting picked off by eagles or something. I see the roosters. They're right over there. Yeah, we need to reset the rooster. I don't know how. We got to like pull on the tail feather or something. But all right, I think I've been stalling long enough. Let's get into this. And if you are late, what we're doing is we're going to talk about opening statements, what they should be from a legal perspective, what they teach you in law school, essentially, and then we're going to compare and contrast a couple of examples from the Karen Reed trial and the Christopher Schurr trial. So let's pull up this. All right. I love my PowerPoint. The importance of the opening statement. So this is interesting. So the Chicago Jury Project, this was in the 1960s. This was a survey done. And it found that 80% of jurors make up their minds during the opening statement and never change their opinions. Now that never change their opinion thing has been challenged. And the University of North Carolina came out with a study, and I want to say it was in the late 90s, but I might be mistaken, that says, no, there's only 6% of jurors will not move from their initial opinions. The rest have open-minded and can be persuaded to vote against their initial opinions. But they went into a lot of psychology. The importance of first impressions is key. And also, this is kind of common sense, but the jurors are coming to this case fresh. They haven't spent weeks or months or years with this case. And because of the charging orders that they're giving, they actually have, they're very attentive and receptive to the opening statements. They're like balls of clay at that point, and you can mold them. And they're very susceptible to first impressions. And that is why the opening statement is so important. Now, whether or not 80% of them make up their mind and they're not willing to budge, it's kind of still up for debate, but they are very perceptive. And it's not an opening argument. Who said that? Somebody said that on Twitter. It's not an opening argument, legally speaking. You cannot make arguments. You can only suggest them. You can only make, the evidence is going to show that my client is absolutely innocent, which saying that as opposed to saying my client is absolutely innocent, which is an argument, there's not much of a difference, but you're not saying it, you're just suggesting. I want to cook the rooster and get it different ones. I got to take that up with the wife because she's not keen on that idea. Opening suggestions. Yeah, I like that. All right, let's see if this works. Okay, so the structure of an opening statement. Now, there are two schools of thought on the optimal structure of an opening statement. Now, most attorneys follow the traditional view, and that's what we're going to go over today because that's what you mostly hear. And depending on where you are, or depending on where I'm at, I should say, sometimes I follow the traditional view, especially in front of a jury. If it's a bench trial, I tend to go with this sort of hybrid where I just sort of talk conversationally to the judge if it's a bench trial, because the judge doesn't need this formality. But that's the other alternative. It's more of an informal dialogue, conversational thing. And sometimes you'll hear that. Sometimes it goes really good. Sometimes it goes really bad. But for the purposes of today and the opening statements we're going to review, we're just going to focus on the traditional style. All right. So first and foremost, you want to introduce the client to the jury. Now, presumably you would have done it during voir dire. This is my client, so-and-so. Do you know him? But the jury doesn't really know anything about him, just his name, and they can see his face or her face. And that's fine for that. But when you get into the opening statements, you want to personalize your client. You want to depersonalize the opposition. So if you're in a criminal case, Jonathan Jones, this outstanding citizen, pillar of the community and the state, or, vice versa, the prosecutor would do it to the defendant, right? They'll dehumanize the other side. And that's kind of a psychological important thing to do. But before you rush into the history of the case, you want to put a human face on this. And I've said it time and time again, the jury needs a bad guy, and it can't be your client. So you want to personalize your client so that they don't look to him as the bad guy. It's the other guy. It's some unknown. It's some I don't know, but it's not my guy. My guy is too nice, too good, too whatever. Humanize him. Talk about his family, his education, where he grew up, things like that. Humanize him when you are first introducing him. Oh, that's how you reset the rooster? Yeah. Boil it. Wait. The husband was acquitted. His stepdaughter wanted all the money and pointed to him, but locked his wife. But what? But looked like wife was drunk and fell into fire. I'm not sure what you're talking about. How do you humanize that? Or blaming a third party? Sorry, I'm not getting the context, but that's okay. All right. The description of the purpose of the opening statement. So this is a lot of things we see too, right? Traditionally, after introducing the client, the attorney describes the purpose of the opening statement. What is it? It's not evidence. It's a roadmap. It's a blueprint. It's a movie trailer. It's a whatever. Quit saying it's not evidence. Don't say that. Very limited circumstances, you should say that. Now imagine this. You are representing a criminal defendant, okay? Everything that comes out of your mouth should be beneficial to your client. So if you stand up there and say, by the way, everything I'm about to tell you is not evidence, the jury's just going to tune out. Why are they going to listen? It's irrelevant. You're undercutting your own opening statement before you even start. Now, there could be limited circumstances in which you would want to say that. And it's in the jury instructions. It's written in the jury instructions. The judge probably said it, but you're not saying it. You don't say it. And the only limited circumstance in which that would be appropriate is if the state's case, we're talking like criminal case, and you're representing the defendant. The state's case is like they got all the facts. They got all the evidence. They got all the proof they need, and you know it. And your defense is like, they got to prove it. If they don't prove it, then you must acquit, right? If that's your defense, and it's not a bad defense sometimes, but if that's your defense, then say everything that guy just said is not evidence, because you go after the prosecutor, right? Everything that guy just said is not evidence, not anything I say. So stay away from that, but use the affirmative. This is going to be a roadmap. This is going to be a blueprint I'm going to tell you how this case came to be, what shenanigans transpired, what whatever, what the evidence and the witnesses are going to say. But don't undercut your own your own statement. All right. David's getting ideas. All right, I'm going to catch up with the chat here. Wait, who are we talking about? He had a great lawyer. The wife that fell into the fire pit. What case are we talking about? Am I like missing some of my chats? Hey, Fox, become a member. Thank you very much, Fox. I am going to probably have to repost a link to the Discord after this, and we will get that up so you can get in there. Melanie Ferris. I don't know that case, do I? It sounds familiar. Whether the fact. Oh, okay. No. Bullet holes in with band-aids. Can't heal both. Hey, Pam Graham. Welcome. Half Irish. All right. So, name the theme of the case. All right. So, this is also important. They teach you this in law school. You got to come up with a theme for your case. It's one sentence that should be able to digest the entire case. And what's important about this is it gives the jury something to grab onto. Like late in the game, in the OJ case, they came out with the glove don't fit, you must acquit. That's a perfect theme, right? They came to it at the end of the case, and they used it in the closing arguments. But it would be even better if you were able to come up with a theme that strong from the get-go, right? So you want to come up with a theme to your case and boil it down to one sentence. There's a couple of examples. Like the prosecutor might say, this case is about a battery, the beating of Mr. Peter Williams on January 19th last year by the defendant. It doesn't have to be anything spectacular, but it's one sentence that boils the entire case down to that theme that you can just run with. And then you can keep that throughout the case. So every time you're cross-examining a witness or examining a witness or doing your closing arguments, you all circle it back. And the defense could be it's mistaken identity, misidentification of my client, no car accident. There was no impact of John O'Keefe, right? There's no vehicle impact of John O'Keefe. Whatever it is. We don't know what happened, but it wasn't my client's car that hit him, right? I mean, that's a theme. You boil it down to one sentence that the jury can grab onto and run with that. That one didn't work so much. Which one? Hocus Pocus out of focus? Oh, Hocus Pocus out of focus was all right. I mean, it wasn't a theme of the entire case, but it definitely attacked the credibility of that pinch and zoom expert, right, in the Rittenhouse case. Hocus Pocus was brilliant. He was trying to come up with a glove don't fit sort of thing, and yeah. How can you use this information when arguing with people IRL? Well, going back a few pages, they have to be open and receptive at the time of the argument. They have to be attentive and receptive. So if they're attentive and receptive at the time and they're not just being dogmatic, then I assume you could use this. I mean, you could take a simple sentence and try to convince everybody. Actually, I do this with my kids sometimes. When my son or my daughter, when they do something or when they say they want to do something, and I'll say, I feel like that's a bad idea. And then we have like an hour-long conversation. And then at the end, I was like, would you agree with me that would be a bad idea? I mean, so you can do it in some ways, I guess. Let's see here. Okay. Simplification of the theory. This is another thing, too. We don't need to argue every single stupid little fact. And I keep harping on this with these long trials that we watch that go on for weeks or months. And they're bringing in every little detail, bringing every little scrap of blood. Like in a self-defense case, we don't need to prove that the victim is dead or that he was shot. We don't need DNA evidence for this. We've stipulated to this. We agree that the defendant shot and killed this person. He's claiming self-defense. So let's skip all that. And that's what this really has. Again, we're talking about opening statements, but you want to simplify it for the jury. You want to say literally that. If you're the defense in a self-defense case, we're not going to contest that the victim was shot and killed on this date by my client. He agrees to that. In fact, he's the one that called 911. Nobody disputes that. The issue in this case fundamentally comes down to, was he in reasonable fear of great bodily harm and or death at the time he shot him, right? So you break it down to its pivotal elements. Lally. All right, so this is where we get into most of the problems that I've seen. It's the style and the delivery. Now, in the 19th century, I've read some transcripts. In fact, I was going through the Lizzie Borden transcripts, and they have opening statements. And the attorneys in the 19th century were so flamboyant and flowery. Just think of like the Gilded Age, right? That sort of stuff. And then modern attorneys have gone in the complete opposite direction, and they're extremely low key and businesslike. And it's horrible. This is the show. You're on stage. None of the law matters at this point. You need to be entertaining. At the end of the day, you need to be entertaining. Yes, you are dreaming. Excited utterance. Welcome. All right. So the attorney should use simple lay. The irony of this. I cut this out of the book. The irony of saying the attorneys should use simple lay diction. Who uses the word diction? I think they put that there on purpose. Avoid legal jargon. There's no reason to say diction when you could just say words, right? There's no reason to say prior to when before will work. There's no reason to say motor vehicle when you could just say car. Use plain, ordinary diction. And then you can also be grammatically incorrect, I should say. Stop halfway through a sentence to make a point. Things like that. Speak conversationally. Jurors don't like formal writing style lectures to them. So stay away from that. Talk like the juries do. In fact, part of the study also showed that there's something like 60% of the jury makeup are blue collar workers with high school education. That's your level. You should be talking like newspapers write. They say like newspapers write to like the 7th grade level. That's what you need to be doing. Put variety in your voice pattern. Everyone has at least several octave range. A monotone can be deadly, as we shall see coming up. No monotone. Be conversational. Inflect. Deflect. Change your pattern of your speaking. It will shake things up. She called alphabet time dictation. Oh my God, really? She's talking to kindergartners and she calls it dictation? That's horrible. Havoc. Yeah, Havoc. Havoc was great for, what was it, Minnesota, Wisconsin, whatever the hell it was. Havoc. Perfect. Does this advice apply equally to defense and prosecution? Okay, Mads, technically yes, but if you are a prosecutor, do the opposite of everything I'm saying, just so, because you guys are horrible. But yes, it applies. It applies to everything, to both sides. Whether you're a plaintiff's attorney in a civil case, your defense on civil or criminal, your defense on criminal, doesn't matter. It applies everywhere. And more, I found it to be a good practice, even in front of judges, for motion arguments and things like that you're doing. You don't need to go super formal. We've gotten away from that since the 90s in the legal profession. And while your typing should be a little bit more formal, your speaking should definitely not be. The attorney must maintain eye contact with the jury during the opening statement. The attorney does her client a horrible disservice by reading the opening. You notice I put these in PowerPoints. I have an entire paragraph or chapter of a book I could just simply read to you guys. I'm not doing it. It's horrible. Don't read. Also, gesture effectively. Do not rivet your hands to the lectern or hold them behind you. If you constantly hold your hands behind your back or lock them in a prayer position, you project nervousness to the jury. And juries might suspect your nervousness because you doubt the legal merits or the factual merits of your client's case. Your posture should be straight and erect. Do not slouch or lean on railings. Again, common sense things. Like when you hear it out loud, you're like, yeah, that makes sense. But there's so many attorneys that just stand there with their hands rigid on the lectern, talking to the jury, reading from their opening statement. It's horrible. Your movement during the opening statement should also be purposeful. You shouldn't just constantly be wandering around. You should move a position to make a point, to emphasize a point. If you're standing here and you're talking to the jury about this, and you're going on to another subject, take a few steps. Turn sideways to the jury, take a few steps, and then turn back. It signals to the jury that you're moving on to something else. Now, with these things, I've created this checklist. And we're going to go through, we're going to watch 2 opening statements now. We're going to watch, the first one we're going to watch is from the Christopher Schurr trial. This is the defense opening statement. And we're going to go through and try to figure out, I'm going to see if I can do this with the checklist in one screen and the, so you guys can keep an eye on it. And the video playing on another, side by side so we can check this out. But introduce your client, humanize and personalize your client. Identify the purpose of the opening statement, not negatively though, affirmatively. Let the jury know what to expect at trial. Identify the theory of your case, simplify the theory of your case, speak plainly, avoid legal jargon, put variety in your voice pattern, maintain eye contact with the jury. Do not read your opening statement, gesture effectively, and move around, but not aimlessly. I feel like that's a good summary. Never ever, yeah. Don't ever rest your head on your hands. Who did that? Oh, please tell me there's something out there. The Daybell prosecutor in Lori's Idaho trial started off by saying this case is about sex, money, and power. Yeah. I think that was good when you're talking about the Daybell case. This case is about sex, money, and power. Yeah. Yeah, that's a good theme to have. You see streamers do it occasionally. Talking about Baker. You can't be in here bashing Baker, man. All right, so let me close down this slideshow. And yes, save it, please. Save it, please. All right, we're going to see how this works. I don't know if this is going to be terribly effective. Picture in picture, please. Thank you. The problem is I'm missing a monitor. One of my monitors in the month since I've streamed decided it didn't want to work anymore. So it's becoming a little more tedious to do what I want to do. So it's going to take me a second to set up the screen, but it should be okay. All right. That's the wrong case. This is the Jennifer, or that's the wrong case. This is the Karen Reed case. That's not what I want to start with. I want to start with this absolutely horrible train wreck of a case, or opening statement rather, in the Christopher Schurr trial. She did such a disservice to her client with this opening statement. I'm just so happy that they were victorious in the end because, as I said, if you didn't watch my stream, I thought he was guilty until the trial. And I'm happy that it was ended up being a not guilty. All right. I don't know if we can see the entire playlist with my beautiful head here. Let me move this. Oh, how do we do this again? Where is my overlay? Why can't I find my overlay? There it is. Overlays. Get rid of it. Okay. Let's just try this. Let's see how this goes. Volume is up. All right. Let me know if you guys can't hear. I remember this case being a little bit difficult to hear. So we'll see.
Good morning. I'm Michaela Hamilton, and it's my privilege to represent Christopher Schurr. Let go of the taser. Let go of the taser. Drop the taser. Those are the final commands that Officer Schurr gave to Mr. Loyola before he was forced to make a decision he hoped never to have to make. What you'll learn from the evidence in this case and throughout this trial is this is not the murder case that the prosecution reports this to be. This case is about.
I'm at a Kentucky Derby tea party for that picture.
Self-defense, which is, as the judge will explain, is a justification to murder. The prosecution will try to make this as something it's not. They'll use words like excessive, unnecessary. They'll call Chris Schurr a murderer for doing the very job we asked him to do, for protecting the citizens of Grand Rapids and for protecting himself. And the evidence will show that this was not murder. This was self-defense. This is about a man who is doing his job as a peace officer, a man who took an oath to protect, to defend, to run towards danger when others run away. The evidence will show that Officer Christopher Schurr did everything he could to avoid using deadly force, even after being disarmed of his taser. He fought with Mr. Loyola for over a minute to try to get his taser back. And you'll see he tries to turn it off. And when he couldn't, when he lost all control, he was forced to make a split-second decision, one he hoped never to have to make.
All right. So Johnny says, wow, this isn't great. But what's great, what's not great about it, right? Like, we're going to dissect this with this list. So first of all, you want to introduce your client, which she did. But she skipped over the humanizing and personalizing your client. She did it a little bit, but not really. She almost went straight into what to expect at the trial. Like, she skipped identifying the purpose of the opening statement. This is what I'm going to tell you is, what happened here. You can do it in an interesting way. I think she tried to come out with a little too much. I don't want to say emotion, but she skipped a lot of points. I think later, and I haven't watched it in a few weeks, but I think later she tries to go back and to personalize him, but it's kind of lost already because you're already now into the meat of the case. And you skipped a bunch before you got there.
He didn't choose to take a life.
Yeah, a lot of little
energy. He chose to save his own. And we trust that after hearing all of the evidence,
and I think she's
hearing all of the facts, the evidence will show that Christopher Schurr is not guilty.
Okay, so she looked at her book between all of the evidence and all of the facts. She had to look at her book for that. She's reading, right? And she's hamming it up. You're going to look at all of the evidence and you're going to conclude that he is not guilty. That it comes across as disingenuous. She's been on this case, from what I understand, for 2 years. You know this case. Put the book down, talk to the jury. You should literally have a checklist like the one off to the right of the screen, and that's it.
He is not guilty of any crime and must be acquitted of all charges because he followed his training He followed the law, and he did everything he had to do to survive.
Hey, Jessica.
So I want to take you back to that day, April 4th of 2022. It started as an ordinary day. 31-year-old Christopher Schurr woke up around 4 a.m., which wasn't unusual. Chris was used to working hard. He earned a full-time scholarship to Siena Heights University, and he was a 5-time All-American cross-country athlete. He was born and raised in Byron Center, where he met his high school sweetheart and now wife, Brandy.
Now, let me ask you this. Has anyone spotted a theme yet? Have we developed a theme? One sentence that encapsulates this entire case from the defense point of view. If we have, I might have missed it, but I didn't hear one. And that's important because you want to roll your closing arguments and all of your cross-examination back into that theme.
Here with him today. Chris and Brandy were heavily involved in their church, frequently attending mission trips to Kenya, which is where they chose to get married. Chris and Brandy have always been devoted to helping others.
Hey, Cindy Lou, welcome to
around
membership.
4:30 on that Monday morning, and before going to work as a Grand Rapids police officer, Chris kissed his wife Brandy and their dog Arrow goodbye, telling them he loved them.
Okay, I'll give her some points for this because she is humanizing and personalizing him while at the same time identifying sort of the meat and potatoes of the case. I could see where she's going with that. I'll give her a little bit of a pass.
And Chris arrived at the station around 5 a.m., roughly 30 minutes before his shift started. He always liked to get there early to make sure he was prepared for the day ahead. And when Chris put on his uniform, he became Officer Schurr. And that day, just like every other day, Officer Schurr had one job and one priority: to protect the people of Grand Rapids. He had no idea that within a few hours, he would end up in a fight for his life. Around 8 a.m. on that cold and rainy Monday morning, Officer Schurr was patrolling the southeast side of Grand Rapids. While driving down Kalamazoo Avenue, he noticed a Nissan Altima ahead of him driving unusually slow. And when he ran the license plate, it came back registered to a Ford Fiesta, not a Nissan Altima driving ahead of him. As soon as Officer Schurr realized the plates didn't match the car, he turned around and started following the car. And you'll see the video evidence, and the video will show that the car made 2 abrupt right turns, one right.
I would agree. You know what? I will agree with Luke here. Without the reading, this is a lot better. It's the reading, right? So the jury's not just listening. Presumably, there's no blind jurors. They're looking at her. And that's why I emphasized, don't wander around aimlessly. Gesture effectively, which she seems to be doing with her hand right here. But she keeps looking down to her book and reading. And I feel like she is inflecting her voice, but the wrong way. I don't know why she put so much emphasis on the make and model of the vehicle. I don't know. Just odd little things that throw me off.
And another right. And you'll hear that is a common sign to police officers that person is potentially trying to evade arrest. And as soon as the car stops, before Officer Schurr is able to get out of the car, you'll see that Mr. Loyola jumps out of the car immediately, instead of staying inside like everyone else does when they're pulled over. And because of that, Officer Schurr jumped out of his car and immediately commanded him to get back in the car, just like he's trained to do. But the driver failed to comply. And this is a common theme throughout this case, because Grand Rapids police officers are trained to consider.
Okay. I know you guys are talking about how bad Lally's is, and to be honest, I didn't watch it. But this move where she literally holds the screen up in front of her face between herself and the juror, the jury is no, don't do that.
And this is a common theme throughout this case. Because Grand Rapids police officers are trained
Don't do
to
that.
consider failure to comply.
I don't know, just some
Ask
asshole
yourself
on the
why.
internet. Justin.
As you'll hear, failure to comply with a police officer's lawful commands automatically escalates the situation, raises safety concerns, and creates a reasonable belief that this person could be a potential threat.
Hey, Wendy.
Ask yourself, why was the plate registered to a different vehicle? Why did the car make 2 abrupt right turns? Why is the driver exiting after coming to a full stop? When Mr. Lioya jumped out of the car, it signaled to Officer Schurr that this could become dangerous very quickly.
She shouldn't
But
be
despite
reading, in fairness, she shouldn't be reading anything. She knows the case. She absolutely knows the case. It would be better if she had, like I said, a checklist like mine, with maybe a few little notes under each heading. And just sort of like set that down on the desk. And then she would have a reason to walk back and forth, maybe back to the defendant, stand by him for certain points when she's talking about him specifically, things like that. But you don't want to read at all if you can avoid it. Never read. Maybe a checklist at the most. But if when she turns it, you can clearly tell she's got like a whole script written out. And I think that's why she's so clunky in her delivery, is because she read a script, and maybe she even read it in the mirror, and it sounded good as she read it line by line and emphasized looking at the page. But now she can't look at the page because she's got to look at the jury. And so she's trying to remember her lines instead of just coming across naturally.
this, you'll see that Officer Schurr stays calm. He gives the driver the benefit of the doubt and continues with routine staff protocol, asking Mr. Lioya for his license. But instead of cooperating, you'll see Mr. Lioya evaded questions and demanded to know what he did wrong. Officer Schurr confirmed that Mr. Lioya spoke English and calmly explained that the plates did match the car. Finally, after the 7th request for a driver's license, you'll see the driver pats his pockets.
Okay, Aaron, I guess go
and then
make dinner.
He says he has a license in the car. And he asks the passenger of the vehicle to get it. And you'll see that the passenger could produce a license. And then Mr. Lioya abruptly shuts the door and starts walking away from Officer Schurr. Again, failure to comply. Ask yourself why. Why isn't the driver providing a license?
Failure to comply, ask yourself why. Okay. I don't think that's a good theme for this case, but it's a fun rhyme. It's not a good theme for the case because it doesn't encapsulate the entire situation. This is self-defense, a police officer shooting a suspect. And he didn't shoot him because he failed to identify himself, which is what she was just going off of. He didn't identify himself, failed to comply, must ask why, or whatever her rhyme was. And in fact, the state will harp on that in closing arguments, that he shot him for not identifying himself. That was what the state jumped on, because that's bad theme. I bet you the state picked up on that and was like, what? You trying to say he shot him for not identifying himself? Which wasn't the case.
License. Why did he shut the door and walk away? And you'll hear that officers are trained that when someone tries to distance themselves from a car, it could mean that there's contraband, weapons, or other items inside the car that they don't want the officer to see. All signals raise concerns from the start of the traffic stop. But once Mr. Lioya failed to produce a license, Officer Schurr attempted to place him under arrest. He ordered Mr. Lioya to put his hands behind his head so he could arrest him. But Mr. Lioya continued to ignore his commands. And you will hear that Officer Schurr gave over 29 lawful commands. 29. Ladies and gentlemen, that's 29 chances that Mr. Lioya had to change his outcome safely. Sorry. Hit the screen. And you'll see that Mr. Lioya does.
Right? I mean, that's the essence of the case, is that the suspect started fighting with the officer and grabbed the officer's taser. And so he was then armed. It doesn't matter if he had contraband or firearms in his car. He armed himself with the officer's weapon. So is this simplifying things for the jury? Remember, you want to speak plainly. First of all, I don't think she's speaking plainly. And you want to simplify the theory of your case right here. Simplify the theory of your case. Going into stuff that doesn't matter is not simplifying it. Going into irrelevant things, the fact that he didn't identify, it might inform why the officer asked him to step away from the car, but that's not why he got shot. It might inform him as to why the officer wanted to put him in custody, but that's not why he shot him. So
doesn't just ignore Officer Schurr's commands. He resists, he pushes, he shoves, he broke free, and he runs. And then you'll see that he fought and fought and fought. Mr. Lioya continued to escalate the situation by failing to comply with Officer Schurr's lawful commands. He created a danger not only to Officer Schurr, but to the citizens of Grand Rapids. And like you heard, he was running towards two strangers' houses. He didn't know them. He was running towards their houses after he had just resisted arrest, after he had pushed an officer, after he had shoved an officer. Officer Schurr didn't know what he was going to do or who he could harm if he let him go. As Mr. Lioya called for backup, as Mr. Lioya ran away, Officer Schurr called for backup.
2 open beers were found in the car.
And Officer Schurr tackled him to the ground at a stranger's home, who you'll learn was Wayne Butler and Fred Hunter. Meanwhile, you see the passenger exit the car and start recording on his cell phone. And ladies and gentlemen, ask yourself what Officer Schurr knew about the passenger at this time. You'll see there's no interaction between them. He didn't know who the passenger was.
Sounds so
getting
clunky.
out of the car.
Ladies and gentlemen, ask yourself what the officer knew about the passenger at the time. It's a horrible sentence. Horrible sentence. The passenger got out of the car and started holding up a black thing. The cop didn't know. My Officer Schurr didn't know what was going on. He has no idea who this guy is. Isn't that more compelling than, ladies and gentlemen, ask yourself what the officer knew about the passenger at the time? So clunky.
He didn't know if he was
Simplify it.
He didn't know if he would join the fight. Officer Schurr wrestled with Mr. Lioya in the wet and slippery grass, and the struggle with Mr. Lioya escalated quickly. Officer Schurr tried multiple physical maneuvers as he was trained, but nothing worked. Mr. Lioya was overpowering, and he couldn't get him down. You'll see Mr. Lioya was bigger.
That's a fair statement, Cindy.
He was stronger than Officer Schurr, and he kept resisting. And you'll see Mr. Lioya get up off the ground 3 times with Officer Schurr on his back. One of them, from a complete prone position on the ground, he does a push-up like it's nothing with Officer Schurr on his back. And you're going to hear that Mr. Lioya had a blood alcohol content of 0.29, 4 times the legal limit, which would help explain why it was so hard to get him to stop resisting.
See, to me, that's not relevant either, because the cop didn't know that at the time. He didn't even know the open beer in the car. He didn't know that the suspect had been drinking all night and was still drunk from the night before, and went out with his buddy to the store to get a case of beers that morning and were driving around drinking. The officer didn't know any of that. So that, to me, is irrelevant. You're not simplifying your case.
You'll hear Mr. Lioya yell to the passenger 3 times to get the keys. Officer Schurr called for backup again, expecting an emergency response. But no help came.
Quit reading.
He was left exhausted and alone. You'll hear him on the video, panting and wheezing for air. Throughout this entire encounter, Officer Schurr was following his training. He was following his training, he was following his policy. And after trying to get control of Mr. Loyola to no avail, Officer Schurr had to move up to a higher level of force, since nothing else had worked. So he reached for another tool on his belt, the taser. A less lethal, not non-lethal.
You can tell she's reading from a script when she says he reached for his belt, another tool on his belt. She had that all written out. She has this entire thing written out, and she's reading from it. That's bad. Nobody's connecting with her. The jury is not paying attention to her. I've watched this several times, and it's hard for me to just follow what she's actually saying because it's not at all compelling because she's reading the entire thing. Look, she's reading right now. She's staring down at the tablet. She's not making eye contact with the jury. She's not simplifying the case. It's horrible.
When in the hands of a trained police officer, a less lethal weapon. And you'll hear the taser can be converted to a deadly weapon, especially when used by an untrained person. And you'll hear all of the warnings that police officers are given. And you heard the prosecution talk about some of those warnings, some of those critical areas to avoid. Police officers are trained on how to use the taser to avoid causing serious bodily injury or death to people. But you will hear it is dangerous, it can cause serious bodily harm, and even death.
I like William Hung.
When Officer Schurr drew the taser across his body, he aimed for Mr. Loyola's back, exactly as he was trained. When suddenly Mr. Loyola spun around and squared up to him, and in an instant, Officer Schurr was faced with the worst case scenario. Mr. Loyola grabbed the taser, and once he grabbed it, you'll see he never let it go. And this is the moment that changed everything.
Oh,
Desperate
the cameraman
and
was
alone,
horrible in this
still
case
with
too.
No signs of backup. You'll hear that as soon as Mr. Loyola grabbed.
Didn't everyone expect a video? This is the moment that changed everything. The cameraman expected a video. What are you looking at? You click to another PowerPoint? Let down.
The taser. Officer Schurr was flooded with fear because he knew what it felt like. It causes excruciating pain, incapacitation. It can drop an officer to the ground in seconds. But this fear wasn't just about the pain. This fear was about what could happen next.
Yeah,
If
she has a
Mr. Loyola
PowerPoint, but it's
tased
much worse than
he
mine
could take his
was.
firearm and shoot him with his own weapon, which is something officers are trained to consider. If he went down, he would be defenseless, and his gun would be right there for the taking. And his training was clear. If someone takes your weapon, they'll use it against you. And
Definitely.
despite what the prosecution tries to say, the taser, this is not a toy. You will hear it provides and delivers thousands of volts of electricity, causing your muscles to lock up, causing you to be incapacitated.
She forgot what the thousands of volts of electricity does. She had to look back down and pause in the middle of a sentence. Come on. Now, I don't know this attorney. She's a Michigan attorney. I'm not trying to dog on her. She's got 5 years of practice under her belt. She's been practicing for 5. I don't know how much trials she's done. This is just so bad. It's just so bad.
You'll hear the taser can injure you in 3 different ways. As the prosecutor mentioned, neuromuscular incapacitation in probe mode. The drive stun causes extreme pain. And once the taser probes have been discharged, you'll hear that the taser wires can shock you. So not only is this weapon something that causes serious bodily injury, it can lead to potential death when used improperly. And the biggest risk to police officers is that once someone has your taser, if they use it against you, you will be left defenseless. And Mr. Loya had yet to comply with any of Officer Schurr's commands.
I thought about using crumblies.
Never complied with one.
But again, I have the checklist on the right, which is what you're taught in law school and trial practice. And in my opinion is good. I did change some things up a little bit and added a few things. And I thought this opening was a little bit more appropriate for comparing and contrasting than the Crumbly opening, even though it was pretty bad too.
And the evidence
she had personality, yeah. And she wasn't reading.
That the second cartridge had even been discharged. He didn't know it could only be used in drive stun mode. And frankly, it doesn't matter, because even in drive stun mode, the taser can cause serious bodily injury.
Salvador, quit texting funny pictures of me.
Downplay this. They'll try to say it's not that harmful.
It's not that. She's arguing now, Your Honor. This is not for her to argue against my case, it's to present her case.
I would sustain that.
Ow.
Argumentative. Ms. Hamilton, tone it down a little bit.
Sustained.
Thanks.
Well, we talked about a few minutes ago, what's the difference between an argumentative or a closing argument and an opening statement? Is that you're subtly hinting at the argument. You're not hitting it on the nose. And she was probably hitting it a little too much on the nose.
Throughout this trial, the evidence will show that the taser is a dangerous weapon that can cause serious bodily injury or death. Period.
Just add in, despite what the prosecutor thinks.
Ask an officer to wait until they're injured, incapacitated, or shot to act. And you'll hear from our experts and other police officers that officers are trained that action beats reaction. You will hear how quickly officers are trained.
This cameraman is insane.
On them and injure them with a weapon.
This cameraman's insane the entire trial.
And throughout this trial, the only question for you to answer is whether or not Officer Schurr's fear was reasonable. And the prosecution cannot meet its burden that it was unreasonable.
Argumentative again.
For Officer Schurr to be afraid of Mr. Loya after he disarmed him of his taser, gaining full control of it, trying to fight to get it back for over a minute, regardless of the mode. The moment that Mr. Loya grabbed the taser changed everything. With Officer Schurr's heart pounding, his only thought was clear.
A mega pint of whiskey before every morning in court.
So I can arrest him. For over a minute, he fought and fought and fought to get it back. He shouted, "Let go."
Yeah, you know what? That's a good point, Justin. Like, she mentioned that the taser is deadly force, but she didn't really go into the details. She said it's especially deadly when there's someone who's untrained. But the heart of this is that the officer can be incapacitated with his own taser, and then his gun could be taken, right? And that's what was argued in the trial. But that's not mentioned in the opening statement. So again, what you're supposed to do is identify the theory of your case, simplify the theory of your case. So if that's one of them, you kind of need to hit that. And that actually could be the theme that you develop. You could develop a theme around that, and she just doesn't. She just sort of skims over that. I mean, she heavily emphasized the identifying or the make and model of the vehicle, but then she skips right over kind of like the important stuff. And I don't know.
Go of the taser again and again and again. Officer Schurr tried everything he could to stop it. He tried to turn it off, but Mr. Loya's hand blocked the safety. And then, when Officer Schurr looked down, he saw Mr. Loya holding the taser in his hand like a firearm. And he felt him getting him off the ground.
If you guys are interested in this, I streamed the entire trial. Myself and Nick Staroff Trial Watch. So you can go back and watch it if you want. It was happening during the Karen retrial, so we didn't have that many views. So if you guys want to go back and give me a few more views, that would be awesome. it was an interesting case. It took place here in Michigan, and I was following it for a while. I interviewed the Grand Rapids Police Commissioner, Detroit Police Commissioner for a while when this first happened as well. The defense won in spite of itself.
Again, with the taser in his hand, turning up towards him. And in that split second, he had to ask himself the most terrifying question someone can ever ask. Am I about to die? If he didn't act in that moment, he was afraid.
Yeah, we streamed the whole trial. Nick and I did. Everyone else was watching Karen Reed.
Officer Schurr, completely out of breath, with no signs of backup on the way, with no other viable options, yelled out.
See, I thought the guy was guilty.
Command to drop the taser.
See, I watched the video, and I thought the guy was guilty going into the case, which was very against my nature, and I kind of felt sick and dirty all over for it. But then as the case was progressing, I switched over to not guilty. So the defense knew to call the right witnesses. That's what I'm going to say. They weren't good at cross-examining state's witnesses. They weren't good at even really examining their own witnesses, but their witnesses were great at testifying. So.
And Mr. Leoya failed to comply. Now, throughout this trial, as you're reviewing all the evidence, ask yourself, why would Mr. Leoya let go of the taser if he didn't plan to use it? Why would Mr. Leoya switch it from his left to his right hand? And you'll see this in the video. Why would he do that if he didn't intend to use it? Why would he keep holding on to it after every command to let it go? Why was he holding it like a gun while getting up?
Is your theory why? Like sometimes I use the word choices.
The only question for you to
especially
decide is whether Officer Schurr's belief.
Quit reading it.
In that moment.
Look at the jury. You didn't need to read that. You didn't need to read that, lady. Look at the jury. Look how bad this is. She's not making any eye contact with the jury. She's reading this whole thing.
Why was he holding it like a gun while getting up and turning towards Officer Schurr?
No, I streamed it myself. I did jump on Bronca's stream a couple of times when we had some downtime.
The only question for you to decide is whether Officer Schurr's belief of danger in that moment was reasonable.
Look at the jury.
And you'll hear from our experts. Absolutely.
The experts were incredible in this case. The defense experts
Throughout
were
this
amazing.
trial, you'll hear from several experts. You'll hear about Officer Schurr's training as a Grand Rapids police officer. You'll hear how an exhausted officer would be after fighting for over 2.5 minutes. You'll hear why it would be reasonable for Officer Schurr not to hear the second cartridge go off when you're in the middle of a hand-to-hand fight with someone for over 2.5 minutes. What you hear is any.
It's okay, Cindy. Nobody knew I was streaming. Everyone was watching Karen Reed.
For your life.
And Bronca.
And you'll hear from several of our experts why Officer Schurr was justified in using deadly force. And you'll also hear from the people's experts, including from the taser manufacturer itself. And they'll attest that the taser can cause serious bodily injury or death when used improperly, especially by an untrained and unlicensed person.
The state used that guy, I believe. Wait. The state used somebody from, was it? Oh, no. It was the George Floyd trial. The state used the guy from the George Floyd trial, I believe.
You'll also hear from the People's Police Practices.
Oh, was it Potter?
A professor, a law professor from South Carolina, who was a police officer 20 years ago. You'll also hear from their expert from New Mexico, a police officer from New Mexico. So when you hear from these experts, ask yourself, what are they?
Check, Your Honor, she's arguing again in terms of commenting on our experts. That's not what she's proving. Is what,
So,
Yeah, the state
I'll
was pretty bad,
say
too.
that as well.
When you hear from all of the
What I didn't put on the checklist was try not to get objected to. Try not to get objected to during your opening statement. It doesn't look good. And I will say, as a criminal defense attorney, you need to be prepared for the state to object, because if they can, they will. And they might even try it without grounds, which is fine, because then the court should shut them down. But the state will try to object. They will try to break it up. So be prepared for that and don't give them an in.
experts, consider what they're relying on. And at the end of the trial, the judge will instruct you on what the law is and what you must consider
If they get shut
based
down,
on
Dahlia,
what
it can.
Officer Schurr knew and how Officer Schurr was trained. And the law says that a police officer is allowed to use deadly force if he honestly and reasonably believes that he is in danger of serious bodily injury or death. And when you're answering that question, you must consider this from the perspective of an ordinary and prudent person with the knowledge and in the situation of the arresting officer. So when you're considering all of the evidence, when you're hearing from all of the experts about police practices and the use of force, remember this. This is what you'll have to consider. What Officer Schurr knew, what he was trained. The law does not require perfection. It doesn't ask for hindsight.
That could have been a good
And
theme.
when you're considering your verdict, you cannot sit here as a Monday
You could build in a theme. The law does not require perfection, only a reasonable fear, or something like that. You could build that in. That would have been good.
morning quarterback
I haven't heard a theme.
from the safety of the jury box with unlimited time and hindsight. You're not here to judge what Officer Schurr should have or could have done. You're here to judge what he did in that split-second moment, based on what he knew, based on what he felt, based on his training and his
Double-decker
experiences.
tacos. Nice.
Now, a man died, and that's a tragedy. But not every tragedy is
Not
a
all
crime,
attorneys are created equal.
and not every death means someone has to be penalized. And self-defense is not a crime.
Okay, Mads, fair enough.
You'll
That's
see a
fair
lot
enough.
of video evidence throughout this trial. And we'll go through that with you step by step
I'm
And
trying
there's
to
a
create a
lot of
theme for her
information
because
in
she
the
never
video
created one.
that we
She
will
never
point
came
out
up with one.
that you may not have seen from the first few watches. And as you watch the video, ask yourself whether or not Officer Schurr had a reasonable belief to be in fear of danger, of serious bodily injury or death. Ask yourself, did Patrick Loyola disarm Officer Schurr of his taser? And did he eventually obtain full control of that taser? Ask yourself, did Officer Schurr try to get that taser back?
Apparently, ask
And did he
yourself is her
believe
theme.
that the taser could cause him harm? And the evidence will show that Mr. Loyola was driving a car with the wrong plates. There's no dispute that this was a lawful stop. And then he ignored over 29 lawful commands. 29. You'll see he pushed, shoved, resisted arrest, and then he fought and fought and fought. And then he attempted to disarm and did disarm Officer Schurr of his taser, an inherently dangerous weapon.
Oh my God, will it ever end? Simplify. You should be
And
done
you'll
by now.
hear, he was nearly 4 times the legal limit, unfazed by pain. So it's your job throughout this trial to decide whether Officer Schurr's belief that he was in danger was reasonable. And the prosecution in this case has the sole burden. They have the sole burden of proof. And the judge will talk to you a little bit more about this at the end of the trial. And it's the prosecution's burden to prove all of the elements of the crime, and also to prove that Officer Schurr was not justified, that he was not in fear. It's not our job to prove anything. It's not our job.
Yeah, she like over and under emphasizes words at random that don't make sense with the context of her story, right? So there's so much I don't like about this. And I think it all comes down to one simple thing. Stop fucking reading. If you stopped reading and you just told the story, you'd be so much better.
He was afraid. It's the prosecution's job to convince you that he was not afraid, that his belief was not reasonable, that it wasn't reasonable for him to be in fear after he was disarmed of his taser, after fighting for over 2.5 minutes. And after you see what Officer Schurr went through, after you hear from our experts, ask yourself, is the prosecution proven beyond one single reasonable doubt that this wasn't self-defense? Because if there's any doubt, the law is clear. In a criminal case where one's liberty is at stake, the Constitution demands something far more: proof beyond a reasonable doubt. So if there's even one doubt in your mind, you must find Officer
If I was her
Schurr not
supervising
guilty.
attorney, I would have taken that tablet from her and said, okay, you've spent enough time with it. It's going to stay right here, and you're going to go up and you're going to talk to that jury.
Not guilty of all charges. And at the end of this trial, we trust that after hearing all of the evidence, you'll understand that this
All of the evidence.
This was survival. This was self-defense. And we'll trust that you will return the only verdict that reflects the truth. That Officer Schurr is not guilty of any crime and must be acquitted of all charges. Thank you.
Okay. I did the wrong thing. All right. So that was the opening statements. And I put that in as the bad. I think it's horrible. And I know it could have been a lot worse, and I'm sure there's been a lot worse. But I wanted to emphasize that she, based on this list, this checklist that we have, right? Let me zoom in here. She introduced her client. That was fine. She did some humanizing and personalizing of her client. But when we get into the trial, we find out a lot more facts about him that could have been put into the opening statement and weren't. Identify the purpose of the opening statement. She didn't do that at all. She didn't say, listen, this is going to be sort of the outline that's going to be presented to you, even from the state. And the state's not going to be able to refute that. And so that could lead right into simplifying the theory of the case, which is the state's not going to be able to refute a lot of these things. So it fundamentally comes down to this and only this. Let the jury know what to expect in the trial. She sort of kind of did. It was kind of hit or miss. Sporadically, she mentioned experts. Sporadically, she mentioned the passenger who's going to be a witness, and she knows he's going to be a witness because he's probably sitting in the hallway. He was the first witness that was called. No, second witness that was called. She didn't come up with any theory or theme of the case. She spoke plainly for the most part. I don't think she used a lot of legal jargon, but she said really complicated sentences where simple, shorter sentences would have been way more effective. She put variety in her voice, but it seemed to be sporadic and unstructured and aimless. She over and under emphasized words at random. It was weird. She maintained no eye contact with the jury. She read the entire thing. Her gestures were okay, but they were hampered because she had a tablet in her hand the whole time. This is not really a grading thing. I just kind of wanted to go through the checklist. Dolly got a wrench, bro. Okay. Yeah, that was a bad one. That's what my thoughts were. Okay, so now we're going to compare it with a much better one, I think. And this is the defense's opening statement in the Karen Reed trial. Hang on, I got to reposition myself now. I'm all over the place. Open, slide, extend. Okay. Now, this is the Karen Reed opening statement here, which I think is a much better comparison to work with. By the way, I will say this was not a perfect opening statement, nor was it a perfect case. No cases are. And that woman right there in the middle was found guilty because she is guilty of DUI.
The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision.
Do we have a theme yet? I'm just curious. I mean, we've only had 3 sentences. I think the theme is fairly strong, right? There was no collision with John O'Keefe. That's the theme. And they come back to it over and over. And throughout the trial, cross-examination, direct examination of their own witnesses, closing argument, they come back to it. It's a strong theme. It's simple. It's something that the jury can grab onto and run with.
John O'Keefe did not die from being hit by a vehicle, period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe.
He came back to it again.
So how did we end up here? How does Karen Reed end up sitting in that chair on trial for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor. He was the lead investigator on this case. And he was talking about a fellow officer, a fellow cop, who owned the property.
He's reading a bit too
where
much.
John O'Keefe's body was found. Text message with a buddy. Question.
But look at that strong eye contact.
Shit?
Even though he looks down.
Answer.
He's looking down at notes. He's not looking down at a script. He's not reading a script. He's got probably bullet points, which is what you should have.
Nope. He's a Boston cop too.
Listen to the emphasis. Changes
that
his
quote
voice
defines
pattern.
The lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a
Identifying.
rush to judgment, conflicted, and corrupted from the start.
Remember, you want to humanize your client and dehumanize the other side. A corrupted department is dehumanizing the other side.
Corrupted by bias,
And it
corrupted
hits
by
hard.
incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it. And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol vehicles, patrol cruisers, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn, literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn. More shockingly, you'll learn that lead investigator for the Massachusetts police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene.
Look, he stumbled over his words right there, right? He wanted to say Boston police officer, and he started off with a different word, probably police officer, and then switch it to Boston police officer. But it's natural because he's not reading from a script. The story's in his head. So it comes off very naturally and very engaging. He's not just reading. I think that was the biggest fundamental flaw with that first opening statement we watched. If she just didn't read, it would have been so much better.
Never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of Michael Proctor's,
he does look down a lot while he's speaking.
In their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation. It's spread through the prosecution from
Don't
the
like that
very
word.
start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's open.
Remember, you want, again, humanize your client, and the jury needs an enemy. Who's the enemy in this case? It's Proctor. There was no collision is the theme. You've established an enemy. Yeah, you're reading a bit, but you're not reading a script. You're looking at bullet points, and he's turning the page. Somebody pointed out, I think it was Mads, pointed out that he's turning the pages quickly, emphasizing that there's very few bullet points per page, and so he can see them and read them quickly. And but he's making good eye contact. He's emphasizing the right words. They make sense with the context. He's not emphasizing the make and model of Karen's car. That, you know, he's emphasizing the right factual issues.
Opening statement. Not once.
Malignancy. We had talked about before you got here, Hella, earlier about using simple words. You know, don't use dictate when you can use the word word. Don't use motor vehicle when you can use the word car. So we talked about using simple words, and he used the word malignant, which is a fairly technical word. It's a medical word. It's not a layman's word. He did eventually then revert to cancer, but I just didn't like that for that reason.
And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it. You'll learn that Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found him guilty, found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case.
Look at the
The
emphasis,
investigation of Karen Reed.
the physical
Conduct
gestures.
that included bias
They're not
in
aimless.
favor of his friends.
He's tapping on the desk to make a point. This case, he's doing everything, mostly everything appropriate. Again, I think he's reading a little too much, but it's not taking away from the points he's trying to make. He's still making strong eye contact. The reason why you don't want to read is because you want it to come off natural. You want it to be engaging. And if you read, it's not engaging. And if you're not making eye contact with the jury, you're not engaging with them. Although he's looks down quite a bit at his notes, he's still engaging and making eye contact.
The all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired? Well, the evidence is going to show that Michael Proctor earned it, every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn.
And I will say about the movement too, I don't know what the rules are in this courtroom. Sometimes judges allow you free reign of the entire courtroom to walk around and talk. Sometimes they keep you in a box. Sometimes they say, don't step out from behind the lectern because they're using microphones. I had one trial in Bay City where the judge had us wear lapel mics and like little wireless things that we had to keep in our pocket so that we were constantly on mic because he liked the attorney to be able to move freely around. But if your system is not set up for that, then they say like stay behind the lectern so that we can hear you. You know, so each courtroom is different. So I'll give him a little bit of the benefit of the doubt. I feel he's trying to step away from it, and I feel like if he was allowed to, he would have stepped away from the lectern a bit. But I don't know.
On Michael Proctor, the lead investigator, who had investigated exactly nothing up to this point, right at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any shit, end quote. And that was for one reason and one reason only. He's a Boston cop. The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking, he actually said the quiet part out loud. He's a cop too. We'll give him a pass.
Okay. The eye contact, the physical gestures, the changing his voice, all of that in that last little bit where he wanted to emphasize the cop, you know, he said the quiet part out loud, which is what he did. He said the quiet part out loud in a text message. That was perfect. And that's that's what I'm trying to get across here. You can't get there if you're just reading. You can't. If you're just looking down and reading. There were many opportunities for that young lady in the other opening statement we watched to do something like that. And she tried, but she was reading a script. And so when she would exclaim something, get the keys, for example, in that other opening statement, get the keys, get the keys. It wasn't compelling. She was reading from a script.
You'll learn that in Michael Proctor's world, rank has its privileges. And the evidence will show that's privileges that you don't get and I don't get. But apparently a Boston police officer, Brian Albert, and his friends, they do get. You'll learn that in Michael Proctor's world.
Look, he didn't need to, when he misstated Brian Albert's name, he didn't need to stop, look down at his notes, read the name for half a second or a second, and then look back up and say the name. He was able to catch himself. He knows this case. He's been working on this case for 4 years now. But that other woman's been working on the case for 2 years. She knows the case. It's not that complicated.
He didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Alberts' house that night. I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture, but the actual true facts that you will learn through the course of this trial.
This is simplifying the theory of the case.
2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate. They were loving. They were in good spirits. Nothing out of the ordinary.
Humanizing the
They started
defendant.
at a local watering hole called C.F. McCarthy's. You've heard that name before, and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up. When they got to the Waterfall Bar and Grill, the Albert family was already there, already heavily drinking.
Welcome, whiskey.
You'll learn that this was
That's
no
on my other
ordinary
private
family,
stream.
the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the Waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter,
Yeah, that's
Caitlin
definitely
Albert,
sort of like an underlying tone in this, right? That's definitely an underlying tone. The police are royalty. They get away with everything. Karen is just like you and me. Yeah, you definitely get a hint of that.
was
for
there.
sure.
His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man
Welcome,
by the name
Jessica.
of Brian Higgins,
Thank you for becoming a new member.
also a law enforcement officer and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Brians, had been drinking most of the night together.
If you are a new member, I'm going to post a link to the Discord in my channel under the membership tab after this.
You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts.
I vote she's
But
found
days
guilty
earlier, she had put a stop to it. She
on
had
all counts.
ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going.
That last statement was a little bit argumentative, but state's not objecting, so that's fine. Again, when you kind of want to try to avoid objections, unless they're going to work in your favor, like Dolly said earlier. If they're going to make the state look bad, then fine. But you don't want to necessarily invite objections.
And you'll learn that Karen and John ultimately pulled up to the house. They got out of the SUV to make sure they had the right address. You see, neither John nor Karen had ever been to 34 Fairview. They weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car, in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out. And when he didn't, seconds turned into minutes, and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear that Karen was very agitated. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls him names. There's name calling. But you'll also hear the context of those voicemails. And every single one of them, every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails and to her texts.
Appropriate emphasis. I can't stress it more. The emphasizing the words the way he's emphasizing them are appropriate within the context. And that was just wholly lacking in the other opening statement.
Karen believed John had just left her sitting there, grabbed a beer.
Well, to be fair,
I'm
on again, off again streaming, so you're
the
forgiven.
Evidence will actually show that John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV and went inside the house. And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. And the evidence will show you why.
Yeah, the other sort of unspoken rule, which I didn't put in the list, it's not really unspoken. It's sort of a psychological theory. People can only pay attention for about 45 minutes. I just sat through some CLE training, and it went all day, and they had the sessions in 1 hour blocks. That was too long. Like 45 minutes is really about the limit that a human can like pay attention to something like this. He is he's about a half hour in, so he's kind of reaching that limit, right?
Let's talk about that. We'll introduce you to a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury.
No updates on
He was
Zach's case
completely
right now.
still and incapable of interacting with anyone or anything.
But Hella's restreaming the trial
But the doctor will tell you
over on
something
Excited
more,
Utterance.
and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish
Yeah,
that
fair
John
enough.
O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved out into the cold. And that's where, ultimately at 6 a.m., Karen found him the next morning. You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single
Repeating
injury
is
on
good.
his body consistent with having been hit by a car. Not
One of the reasons why you want to be able to move is because it signals to the jury that you're going to another like subject or topic. And so if he was allowed to move, I think it would have been more effective. It would have been less sort of droning, like we just talked about. It's been a half hour now he's been talking. It's getting a little stagnant. But if you're able to move, and I know Hella says she hates it when people run all over the courtroom. But if you do it not aimlessly, if you do it to emphasize a different, set of facts that you're going to talk about, or a different, part of the case, then it can be effective to keep the jury's attention.
You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr. LaPosada will tell you with medical certainty that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight.
Well, look at that. Not a
You'll take
PowerPoint,
one
but
look
an
at these
actual
injuries and you'll
photograph.
agree with Dr. LaPosada. The evidence will show that these injuries are from an animal,
But where's my
like a
PowerPoint?
large dog, like the large dog that was inside the Albert house that night. You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote, not good with strangers. And of course, John, never having been to the house before, was a stranger that night.
I've seen them ancillarily, Jessica.
You'll
They
also
all
learn
say,
oddly, very oddly, after
somebody in the chat pointed it out. I can't remember who, but all the jurors are repeating the theme of this defense. He was not struck by a vehicle. That was a theme out the gate. He said it 3 times in a row. John O'Keefe was not struck by a vehicle. And or there was no collision or something along those lines. And the jury is repeating that if you listen to their interviews. That's how powerful a theme can be. And that's why you need one. And that other one didn't have a theme. There was no single theme in that case. They got a mistrial for a hung jury, thankfully, in spite of themselves. But that's how important the opening statement and the theme to that opening statement can be.
having their family pet for 7 years. A short time after this incident, the Alberts got rid of that dog. They called it rehoming her. but she was gone. Dr. LaPosada will also tell you that
Maybe
the
I'll do
injury to
another one where I
John's
compare
head
the closings
was not
between the
result
same
of falling
cases.
backward onto a flat lawn,
Might do another stream
cold
like that.
or otherwise. Rather, Dr. LaPosada will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found. The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement. The Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone
He's repeating himself a
is
little
reasonable
bit.
doubt, but there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet from where John O'Keefe's body would have ultimately been, had he actually been there, right after 12:30 a.m., which is what the
Yeah, I
Commonwealth's
think they made a
claim is.
mistake in the
There were
first
nearly
trial
a dozen
to
people who
try
walked
to
out
prove a
that front door
conspiracy, right?
directly adjacent to this the
This
precise
one, the second
spot
trial, was
where John O'Keefe would have been lying.
we don't know, but
Not
it wasn't
a single
her.
person, not one, not a single person, saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also
See,
show
this is
that
getting
every one of those same
this is getting
people
a
drove
little
by
too
that same
long
spot,
and drawn
not
out.
walked by it, drove by it to leave the house.
Like, you don't need to go into all the details and the leading up to it, but that's not just the only thing that's going to give you reasonable doubt. There's a ton of other stuff. There were a bunch of people there, and it was snowing out, and he was dressed in black, and he would have been laying out. You don't need to do all that. No witnesses. There were a ton of people there, and there were no witnesses to this supposed collision. End of story. Move on. Right? You can do it in one sentence.
And still, not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor...
So you could do my one sentence and then go straight into the snowplow driver. Not even the snowplow driver, who was out on the roads with big lights, didn't see him.
He's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth. And he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did. And we found, and we'll introduce you to, Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m.
This is getting too granular,
there was a car
Dakota
parked
says.
in
I
front of it,
agree.
a Ford Edge.
You want to
You're
simplify
going to ask
the
yourself,
theory of your
who's moving
case.
a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn
Keep
that
it
Michael
simple.
Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge. But again, we did. And the evidence will establish that Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those
No,
facts
he does not.
will add to the mounting and the overwhelming evidence that there was no collision.
He's got that permanent smug face where it's just his nose is up and his mouth is closed the whole time.
And John O'Keefe's body was moved onto that lawn. you'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics, even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here. A collision. And there's no evidence of one. Zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are relatively commonplace on Karen's SUV, and none of them are associated with a claim of a collision. Folks,
He's got the jawline
will
of
not
a
lie.
young.
Physics cannot lie. And that science will tell you with certainty there was no collision.
That attorney that was convicted of unaliving his wife and son. He looks kind of like a young version of him. I can't remember his name.
With John O'Keefe. You'll add that to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house
Murdoch,
that night?
yeah.
What were they doing?
Alec Murdoch.
While she slept, what you'll find and what the evidence will show is that they were extremely
Young Popeye.
busy.
There you go.
You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that too is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m.
I'm losing track of the story.
Shortly after Higgins completed that
Started off
late night
strong.
visit over to Canton PD. You'll wonder, what did they...
All right, so we've been going now for seems a lot less time. Let's see. We've been going now for about 40 minutes. And yeah, because it started at 2:07 and we're now at 2:30. So we've been going for 30 minutes. And I'm starting to drift off. I don't know who he just said was at the police department. So Higgins, Higgins is at the police department. Starting to drag on a bit. You're getting into the nitty gritty. You want to keep it simple.
That night. The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations,
no opening
both Brian
statement or
Albert
trial
and
was
Brian Higgins
perfect.
lied
But
about it.
this is great compared to the other one.
They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently.
He needs to
"Explain
come
yourself."
back.
And they both came up with the
He needs
exact
to
same
come back to the
explanation.
theory of the case. There was no
A butt
collision.
dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m.? And why did they both try to cover up that phone call? You'll also learn after this incident and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn, Brian Albert got rid of.
This is theory.
Shortly after this incident, Brian Albert got rid of his house, the whole thing, just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn.
So in law school, they teach you that an opening statement is different from an opening argument in that what you're trying to do is preview the evidence. You're trying to use it as a trailer. The evidence is going to show this. The evidence is going to show that. The evidence is going to hear, you're going to hear the witness that says this. You don't want it to be repetitive, though, because that gets extremely boring. So, but you can't also make an argument. So you have to say things that the jury should expect to hear. And he's doing a fine job with that. He's going too deep into the weeds. He's not keeping it simple. So yes, they train you to do that, but they also, if you're in a trial skill class, train you to not to say it in front of every sentence. You should say it every once in a while so that the jury and the prosecutor and the judge still know you're not making arguments. You're just presenting the evidence that they're going to hear. So like he said, you're going to hear from the medical examiner, the state's own witness who is going to say this and that, right? That's a good way to emphasize it without being repetitive.
And you'll also learn that Michael Proctor looked the other way. He did not
Or you're going to
investigate
learn
any of what I'm telling you. He pre-selected Karen Reed from the start. And he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m.
This could be so much
And you'll
more
learn that
simplified.
according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Celebrite, it's considered the gold standard for forensic tools. You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped according to their own data at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold. Now she
I
misspelled
love
the
that
first
the
word.
typo
Hoss
is now
supposed to be
part of
how,
the record.
but the meaning's the same.
Like you're,
How long does it take
I'm a bad speller,
to die
and my
in
voice to
cold?
text is even worse.
Time-stamped
But it's not recorded in the transcript.
2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m.,
Wrap it
he
up,
makes
man.
a phone
Wrap
call
it up.
that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Hoslong to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own. The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m. And that's when she realized, in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. They'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time, Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus and she backed up to leave her garage at One Meadows. You'll hear a lot about that.
Is he
that
keeping it
address,
simple,
One
folks?
Meadows. That was John's house where Karen was staying.
Is he
She backed
keeping
out of
it
the
simple?
garage, and during the course of the trial, you'll hear that she actually struck another car with that right rear taillight. During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe. They'll have no evidence of it, mind you, none, but they'll make the claim.
Now you could, I keep saying, is he keeping it simple? He's going too much into the weeds. You could make an argument that he needs to talk about all these things, but I'm not sure that he needs to go into this level of detail when he talks about these things. That's kind of my point. Again, you want to simplify the case. You want to say, listen, these are the things that are undisputed. The state's even going to agree with this, but it's not going to amount to a cause of action here or a conviction, right? You want to simplify it, narrow down the issues. He did great for the first 20 to 25 minutes. And now I feel like it's getting too much into the weeds. The jury is lost. I'm lost. I know the case. I know the players. I've been following it. The jury presumably hasn't. So it's not simplified enough.
We'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off and he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally.
I agree, John.
You'll see it for yourself.
Again, and I come back to the biggest difference between the first opening statement and this one is that the first one, she was just reading a script. When she'd stumble, she'd back up and go back to the script. She didn't have the emphasis that she needed. And this one is the complete opposite as far as style and presentation. Now the words on the paper are a little different. Where he's going with the statements he's making, it's dragging on a little bit. But I agree with you that he's keeping you engaged because of his tone and the fact that he's not reading it to you.
It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John?
Trying to drink
Why
from
hadn't he
a
come home?
fire hose, right?
What had
That's
happened
the
to him?
saying.
Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him. And she was worried about possibly the worst. He had gotten out of the car. He'd walked to the house. She was confused. And later, when she found him at 6 a.m. on the lawn, where she last saw him going toward the house, her mind started reeling, oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him? And that video clip that you saw, out of context, when she said the words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him. That's what she was talking about. Your job will be to make
Angry
sure
there, and I like it.
that the evidence
You brought me back
presented
in.
to you too cute by half. She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other, a woman desperately trying to piece together what could have happened on this tragic night. John didn't come home.
It is
And the
also
evidence
good to
will
get
show
out
that
ahead
Karen
of
Reed
things that could be
never
negative.
said,
case.
I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that the evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Sarath, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there, watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, I hit him. Not one. Not one civilian reported having heard Karen Reed say, I hit him. The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert, Brian Albert's brother. And remember, Chris Albert, the other brother, is a board selectman to whom the Canton Police Department reports.
My brother Daryl, my other brother Daryl.
And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years long close personal friends with a young woman named Caitlin Albert. You heard that right. It's Brian Albert's daughter. During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family. And that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn.
Let's see how he wraps this up. He's almost done.
That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went. Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, alone with video footage, alone with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants. He transported the evidence. He secured it. He submitted it. He did it all. That's Michael Proctor. And he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants. He lied under oath. He lied about the time that he actually secured
Wasn't
Karen
there
Reed's
another
vehicle.
lie discovered
Why?
during this
Why would
trial?
he lie about that?
Something about
The evidence will
lying
give you
to
the
an
answer.
FBI agent.
He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were 2 searches. The first and second search found 0.
Back into the weeds again.
Nothing around John's body.
Back into the weeds again.
Not one piece of taillight.
Notice what I have highlighted.
But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items.
Yep.
46 pieces of bright red taillight laying in the snow, supposedly found in the exact same spot that was searched not once, but twice by independent officers. It came up with 0. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned? They're going to try to dazzle you with talk of DNA because it sounds so scientific. The DNA was on the taillight, but you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show, was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found, John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that that SUV hit 3 men that night, their entire theory falls apart. And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled.
All while this opening statement is going on, Fox?
5. Count them. 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person.
You got 3 minutes left in your opening statement. Bring it home.
About the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you.
Or that theme, rather.
In this trial.
Come back to that theme.
The evidence will show that that is reasonable doubt. Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing.
Dehumanizing the
state. But all
state.
that smoke and all those mirrors will not ever reach their burden. Because that's what this case is ultimately about. It's about the Commonwealth's burden of proof. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the House And the utter lack of investigation speaks volumes about those who actually have something to hide. By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision.
There we go.
She's
Bring
the
that
victim
theme
of a
home.
botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all three of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty. Thank you.
All right. So that was opening statement from the defense in the Karen Reed trial. If you guys are coming in late, we went through the sort of requirements for an opening statement, and we came up with this checklist. We compared it to, let me make this a little different. No, that's too much. That'll work. We compared the opening statement from the Christopher Schurr trial, the defense's opening statement, to this one. And I have to say, hands down, this one was better. Now, did it go on too long? Yes. Did it get too much into the weeds? Yes. But why was it so much better? And I think the fundamental reason is down here. He spoke plainly. He avoided legal jargon. He didn't have long, complicated sentences. He put variety into his voice pattern, which the other defense attorney did too, but she emphasized random words that didn't make sense in the context of the story. Whereas here, he emphasized and got angry and shouted within the context of the story he was trying to tell. He maintained great eye contact with the jury. Even though he stepped out to look at his notes every once in a while, he always came back and made direct eye contact with the jury. He didn't read, which is the next one. He wasn't reading his opening statement. He gestured effectively. He, tapped on the lectern when it was appropriate. And he also moved when he could. I understand this is a small courtroom. Maybe he wasn't able to move as much as I feel like he wanted to, but he moved appropriately. At one point, he was talking about Karen Reed and that they were having a good time or something like that. And he walked towards her to emphasize, this is my client. This is Karen Reed. He humanized her a little bit. And he used that moving around, the little bit that he was able to do effectively. And although I have some issues with this highlighted one, he didn't really simplify the case as much as I probably would have. I can't fault him for it because it worked, right? At the end of the day. And again, no trial, no opening statement is perfect, but it's so much better simply because I think he wasn't reading a pre-prepared script. He was telling a story in a compelling way to the jury. Did we win yet? Yes. I guess. I don't know. I didn't watch the trial. Did we win? So that was the purpose of today's stream. I wanted to try to keep it under 2 hours. I did not succeed. I'm a little over 2 hours, but that's all right. But I really wanted to, after watching the Christopher Schurr trial, which I streamed in its entirety while the Karen Reed case was going on, and nobody was watching me. But I did stream it in its entirety. And watching the defense struggle so much, I felt like I wanted to do a compare and contrast. So that's what I ended up doing. And hopefully you guys learned something from this. And it wasn't just me talking, aimlessly. I'm going to redirect you guys now. By the way, tomorrow at 1 p.m. Eastern, I'm going to be streaming the Brian Koberger, whatever his name is. I'm going to be streaming his plea hearing, mainly because I started covering that case and I was intending to cover the trial if I could. And since he's taking a plea now, the coward's way out, I'm gonna stream it. I had the trial stream set up, so I just changed the date. So tomorrow at 1, if you guys want to watch that along with me, if you're not watching it on Bronca's channel, Cindy, come join me. In the meantime, I think I'm going to redirect you guys over to Sean. I think he's streaming. I just got to get into the guts of the stream so I can redirect. Michigan v. Christopher Schurr. It's not made for kids. Got to do all that. The stream is not made for kids. Nope, that's the wrong one. Isn't Sean streaming? Potentially criminal. Yeah, he's streaming. Okay, that's what I thought. 1 p.m. Eastern. Yeah, it's 11 a.m. out in Idaho. And so that should be 1 p.m. me time. So that is noon for you, Joan. Let's see. Does this count as my continuing legal education? You know what? It should, because everything I took was from a trial practice manual that I got in law school. It's Trial Strategies and Practices, published by Thompson West, I believe. And by the and if you guys are interested in reading the rest of it, because it does go into quite a bit of detail, and it even gives you an example of how you should write out your bullet points for your opening statement and not a script. I'll put it in Discord so everyone can have access to that and read through it if you're so inclined. Yeah, 11 Mountain Time. The best time. You know what? Time zone should just be the same. It should be one time zone around the world. I'd be happy with that. Let's see. You're putting it in your calendar. Why don't you just go to my channel and hit notifications? Notify me. Just send it to me. Send it to you. I'll send it back. I'll send it to you. Send me I don't use it anymore. It's a textbook, and sometimes I keep my textbooks behind me. But I thought it was good to grab for this. Everyone should use UTC. What is that? What is you? Oh, no. No one should be using it. It should be Eastern Standard Time around the world. See, Zachary Anderson's attorney did a fantastic job humanizing Zach. Yeah, her opening statement was very good. It got interrupted though, right? In like halfway through, and then there was a whole day of hearing, and then she was able to finish it. That's horrible because the jury forgot everything she said. She should have started over, but she didn't. I don't know if she wasn't allowed to or if she just wasn't thinking about it. I feel like she should have started over. But yeah, it was a good opening statement. And that was the first case that I streamed. And I watched the state's opening statement and I was like, ooh, like a little love triangle. This could be kind of interesting. And then I listened to the defense's opening statement. And I was like, oh, I don't know about this. This guy might not be so guilty. That's the purpose of the opening statement, right? The first impressions that the jury has of the case, outside of the voir dire, which really, they don't give you a ton of information, is the opening statements. And it needs to be compelling. And while the Chicago jury study said that 80% of jurors make up their mind and are immovable after the opening statements, and I don't know about all that, but the fact is that a lot of people do, or at least they get on your side, right? They tend to lean one side or the other. They might not have an immovable perspective of the case after the opening statements, but they're definitely going to be on somebody's side. This is human nature. So you want to get them on your side. You don't want to be boring. You don't want to be reading from a script. You don't want to be alienating. You don't want them fixating on the fact that you're carrying and staring at a tablet the entire time instead of the words that you're actually saying. It's a show. The law is over with at this point, presumably. You've had your motions. You've developed the jury instructions. You've gone through your motions in limine. The witnesses are all lined up. You've made your arguments to the court. This is a performance now. It needs to be compelling. And that's hopefully what I got across with some extra. And we'll leave it at that. Let's see. Eastern time is the only time that matters. True that. All right. I'm going to leave you guys. I'm going to send you over to Sean. Tell him I sent you. And let's see. There it is. All right. Take care, all.
When I was young, my daddy said, gotta keep one eye open in your bed.